We're back with a Fox News alert. Moments ago, the Supreme Court ruled that women's access to the abortion pill, Mifepristone, will for now remain in place.
Good evening, everyone. We've got breaking news from the Supreme Court. Moments ago, the High Court blocked in full a decision by Texas-based U.S. District Judge Matthew Kacsmaryk on April 7 that invalidated the Food and Drug Administration's longtime approval of the abortion pill Mifepristone. This means the Supreme Court has allowed the pill to stay on the market and remain widely available, at least for now.
Welcome to the NewsHour. The abortion pill Mifepristone will stay on the market for now after a highly anticipated Supreme Court decision maintains the status quo for the drug's access.
There's major breaking news over at the United States Supreme Court right now. CNN's Jessica Schneider is on the scene for us. What are you learning, Jessica?
Well, Wolf, the Supreme Court has just handed down their decision on the application for that stay requested by the Biden administration, and it is, in fact, a win for the Biden administration, the FDA, the Supreme Court here saying that all of those restrictions that the Fifth Circuit had wanted to put on the abortion pill, they're saying that all of those restrictions will not take effect. So it will continue to be status quo for Mifepristone and the way it's administered while the appeals process plays out in the Fifth Circuit.
50% of abortions in the United States are medical abortions, pregnancies that are terminated through the use of medicine, as opposed to procedural abortions. And they're available all across the United States, for now. But why is that availability in jeopardy? And how did this thing get started in the first place? Well, to understand how this thing started in the first place, you gotta start with this guy. Yep, this guy again, former President of the United States, Donald Trump.
Donald Trump. Former President Donald Trump.
President Trump.
Look, Donald Trump was a great practitioner of politics in terms of shaping a message. He knew what to say in order to get people's attention quickly.
Crooked Hillary, she is a crooked one.
It could be we're going to run against Crazy Bernie. That could be. Could be Crazy Bernie. He's a crazy man, but that's okay. We like crazy people. We're going to build the wall. We have no choice. We have no choice.
But he wasn't really a nuts and bolts guy. You know who is a nuts and bolts guy? Current Republican Senate Minority Leader Mitch McConnell.
Senate Republican leader Mitch McConnell. Minority Leader Mitch McConnell.
Senator Mitch McConnell will keep his title as Senate Minority Leader.
Now let's bring in NBC News senior national political reporter Sahil Kapoor. He spoke exclusively with Senate Minority Leader Mitch McConnell.
Mitch McConnell has a saying in his book, The Long View. Mitch McConnell says, you can start too late, but you can never start too early. Well, Mitch McConnell had a project he was working on for decades, the reshaping of the federal judiciary. The federal judiciary has approximately 600 judges on it. When Donald Trump was president, and with Mitch McConnell in charge of a majority of the United States Senate, together they seated 200 judges. Yes, 200 judges out of 600. 200! All with lifetime appointments. Yes, you heard that right. Mitch McConnell and Donald Trump seated 1/3 of the entire federal bench. And one of those people they seated? Matthew Kacsmaryk. Well, who is Matthew Kacsmaryk? Matthew Kacsmaryk is the federal judge appointed by former President Donald Trump and shepherded by Mitch McConnell, who just threw the future of the abortion pill into jeopardy nationwide. To give some background on Matthew Kacsmaryk, currently Judge Matthew Kacsmaryk, he was born in 1977 in Gainesville, Florida, to his mother Dorothy, who was a microbiologist, but chose to be a stay-at-home mom. But she remained passionate about anti-abortion issues. He graduated summa cum laude from Abilene Christian University in 1999, attended the University of Texas School of Law, and was the executive editor of the conservative publication Texas Review of Law and Politics. He continued on to become an associate at an old established corporate law firm where he practiced commercial, constitutional, and IP law for 5 years, until he became an assistant U.S. attorney, where he was lead counsel in 75 appeals cases and co-counsel on a number of high-profile criminal and terrorism trials. After 5 years, he left the U.S. Attorney's Office and went to work for the First Liberty Institute, a Christian fundamentalist legal organization. It is noteworthy that here he submitted an amicus brief, amicus meaning friend of the court, to the Supreme Court that stated that a pharmacist in Washington state should not be required to carry contraceptives. Contraceptives! This wasn't the extent of his conservative leanings. They were just beginning.
No, I'm just getting warmed up.
He also wrote an article from which he had his name removed.
And like that, he's gone.
Supporting the idea that physicians should not be required to perform surgeries on transgender persons or perform abortions. He was nominated 3 times to the federal bench, losing the first 2, and then being approved on the final nomination. He is also independently wealthy due to shares he inherited from his grandmother, who was granted shares of the non-publicly traded Texas-based grocery chain, Publix. Needless to say, at this point, he's about as conservative as they come. As a federal judge, he hasn't missed a chance to strip away protections from members of the LGBTQIA community on a number of occasions, and enforced Trump's original Remain in Mexico order for illegal immigrants and/or asylum seekers. So when a group of Christian fundamentalists, the Alliance Defending Freedom, sought to have the medical abortion drug Mifepristone banned, who did they turn to? The newly minted judge, Matthew Kacsmaryk. And he delivered. He banned the drug, but in a rare act of judicial restraint, because he sure didn't practice any when he wrote the opinion, using language widely used by the anti-abortion movement.
Lisa, he mentioned political decisions out of the courts, and I think that very few would argue that that's not what's happening. And that started with this Texas judge. And I want you to just talk a little bit about this judge, because this is an unusual case. The people who he's saying have standing are doctors who say that somewhere in the future they might have to treat a woman in an ER because at some point she took Mifepristone. It's their job to treat women in the ER. I don't understand. I'm not a lawyer, but I don't see how they have standing to sue at all. But he let them do it. And his ruling, you want to talk about Alito's ruling being churlish, it read like a conservative screed. It didn't even read like anything I've ever read on SCOTUS blog. What is this guy's deal?
This guy, Joy, we know that he was raised in the conservative movement. He was raised actually in the crisis pregnancy movement. His mother was a long-term volunteer. His sister lived for some period of time in a home set up for unwed mothers who were committed to having their children and giving them up for adoption. He later served on the board of that organization.
Amira, you wrote a piece for The Atlantic recently, and you said this unprecedented ruling by Judge Kacsmaryk of Texas is not just a bid to block access to abortion pills. You wrote, quote, "It's an open invitation to anti-abortion rights groups to use the Comstock Act, a law passed 150 years ago and rarely enforced in the past century." Tell us more about how this law from the 1870s has to do with access to abortion pills.
Yeah, this is a strategy we've seen crop up in lots of different parts of the anti-abortion movement recently. But in this suit, the Alliance Defending Freedom and their client, the Alliance for Hippocratic Medicine, essentially argued that this 1873 law, the Comstock Act, makes it a federal crime to mail Mifepristone. And the language of the act is pretty broad. It covers not just drugs intended for abortion, but drugs adapted for abortion, which, as you can imagine, could be extraordinarily broad. And Judge Kacsmaryk said the text means what it says and says what it means. We don't need to worry about the fact that federal courts have not interpreted the Comstock Act this way since the 1920s. So going forward, if the language is that broad, we're likely to see challenges to other abortion drugs and devices as well.
Culmination of decades and decades of a conservative effort to reshape the courts. And I think perhaps no one is more emblematic of this at this moment than this judge in Amarillo, Texas, Judge Matthew Kacsmaryk. I want you to just listen to some of the language used in this ruling that I think tells us a lot about where this is going. Mifepristone is a synthetic steroid that blocks progesterone, halts nutrition, and ultimately starves the unborn human until death. Jurists often use the word fetus to inaccurately identify unborn humans. He also writes, many women also experience intense psychological trauma from seeing the remains of their aborted children. The point being, the language used here is very much in the anti-abortion world, and this entire ruling is framed in that way. Tell us why.
The language was really striking to me, Abby. As you said, unborn human instead of fetus, abortionist instead of abortion provider. It is really textbook from what you hear from the anti-abortion movement. And it really goes to the history of this judge. I mean, this is something that I've reported on a lot. He has a long history of very anti-abortion beliefs. Just last night, we had new reporting showing from a parenting blog published years ago that shows his toddler wearing a shirt that says, "I survived Roe v. Wade." And under that, his wife had written, "As you might guess, Matt loves this shirt." And I think that just really goes to show, you know, how passionate he is about this issue.
He gave the Biden administration a 7-day stay to appeal the ruling. The only problem, they had to appeal it to a less conservative, but only slightly less conservative appeals court. This appeals court modified Kacsmaryk's ruling, but only slightly.
That's right. The court ruled the abortion drug known as Mifepristone can stay available at least for now, but the judge's order also imposed new temporary restrictions on the drug. It can no longer be sent through the mail. Now, the drug is also now only approved for use up to 7 weeks of pregnancy when it was previously 10 weeks.
We're not going to approve of the changes that the FDA made in 2016 and then again in 2021. And that does exactly what Errol said. It means that there will be more limited use of Mifepristone, and it means that you will have to go in person and have 3 appointments in order to get Mifepristone. You cannot get it through the mail.
The Biden administration then appealed to the U.S. Supreme Court. And when they appealed, they weren't alone.
A show of force from Big Pharma, now wading into the battle over a widely used abortion pill. More than 600 drug makers and biotech leaders signing on to a scathing condemnation of that ruling by a federal judge in Texas, invalidating the FDA's longtime approval of Mifepristone, accusing the judge of activism.
It's now been shown that courts can step in and overturn a scientific decision.
Dr. Amanda Banks, former CEO of Blackfin Therapeutics, who co-authored the letter, says the judge's ruling sets a dangerous precedent that extends beyond the abortion issue.
If one medicine is subject to this kind of outcome, really any medicine is.
Well, drug makers have been blasting a Texas court's recent ban on an abortion pill, saying the ruling could hinder the development of new medicines. Yahoo Finance's Anjali Kamlani joins us now with more. Mitch.
That's right, Julie. So a lot of these major companies have been signing on to a letter, as well as have joined an amicus brief that would support the maker of Mifepristone in this Texas ruling. And we know, of course, the government has also filed an appeal. So this just adds to what we know is an ongoing fight. I want to point out that in this letter, the companies have taken a pretty strong stance on the issue, saying specifically, quote, that the judge's decision is basically interfering with the FDA's authority and setting a precedent to diminish that over drug approvals, and in doing so creates uncertainty for the entire biopharma history. So here to join me with more on that is one of the signers and the leader of the letter blasting the decision, Jeremy Levin, Ovid Therapeutics CEO. Jeremy, thank you so much for joining us today.
Good morning. Thank you for having me on.
So tell us about this letter. As I understand it, you started it with a couple of others and made some calls to some of the big pharma companies to get them to sign on as well. What are you hoping the impact will be?
We started this some time ago. We watched the case being filed. We actually thought it would never go anywhere originally. And then as it got momentum in the court, we felt we had to take action. Last Friday, we drafted the letter, finalized it, and then the handful of us circulated it very quickly. The point was that within hours, hundreds, now well in excess of 500 people have signed on. These are the leaders across the industry, the people who generate medicines, actually not just for America, but right around the world. The bottom line is, if we do not stop this, what will happen is you've opened the door to a complete abrogation of the mandate that Congress has given to the FDA. The FDA is the only body with medical and scientific capability for assessing new medicines. We can't hand that to a court, a single judge, and that if we do that, we upend the entire process for developing medicines, vaccines, devices.
So wouldn't you, what isn't the industry already kind of used to being a part of the legal system? You know, people sue against impacts of drugs all the time. We've seen a lot of controversy, like in the case of Aduhelm, you know, the pushback from the public as well as the regulatory body itself. So why would this be any different?
This is completely different. At its core, this judge has challenged the approval of a drug with decades and decades of safety. That safety it was approved appropriately by the FDA. Then we have decades of safety data showing that it's effective and has actually been very instrumental in saving the lives of individuals. Now, there are many other drugs like this, hundreds, to be perfectly honest. That said, if now a politically motivated group can now sue with an individual judge and overturn decades of scientific and medical evidence without having any of that experience, no medical experience, no scientific experience, you throw into question the entire ability to approve a drug appropriately.
You've got to understand that to create a pharmaceutical drug, it's quite the involved process. It takes years of research, data, and money. Lots of money to get the FDA's approval. You have to understand that to run clinical trials for the FDA, it takes an average of $20 million, but can easily reach upward of $100 million. And that's just to test the drug. To actually develop a drug in this day and age can cost up to $2 to $3 billion per drug. So for a single judge to overrule the FDA and pull a drug off the shelves, to second guess the expertise of literally armies of scientists, doctors, chemists, geneticists, and statisticians, let's just say it made a lot of business people very nervous.
And Pam, when these decisions were first being announced, we heard from the White House, they did release a statement saying that the court in this case has substituted its judgment for the FDA, the expert agency that approves drugs. If this ruling were to stand, then there would be virtually no prescription approved by the FDA that would be safe from these kinds of political, ideological attacks. So to that point then, if you're a pharmaceutical company watching this and you're thinking, look, the FDA can be circumvented, what does that do for innovation? How do pharmaceutical companies, what role should they be playing in this?
You know, for pharmaceutical companies, they typically invest, a lot of money and a lot of time in developing medications. They have to go through a whole process of multiple clinical trials, submissions to the FDA, and very rigorous scrutiny. And the sort of outcome of that is that then they can rely on having an approved federal standard that applies across the country in every state. So if this ruling were to take effect, many people in the pharmaceutical industry feel like they could not then rely on that standard. And it could have a tremendous effect really on the decisions they make, on the choices of what medications to develop. I think particularly likely to be sort of targeted by lawsuits if this lawsuit by the anti-abortion groups succeeds would be other medicines and drugs that are politically controversial. So you might see lawsuits against vaccines, for example, or morning after pills, or a variety of other medications. And so you could particularly see some sort of reticence in the pharmaceutical industry to develop those types of medications if they think that they are going to be attacked in a lawsuit by interests that politically oppose that particular use.
So they, along with the Biden administration, appealed to the Supreme Court. And it wasn't pretty.
Lisa, I want you to go through this decision with me because, and I think Ari talked about it in the previous hour, but what I read here is something that kind of reads like shade. This decision, talking about in recent cases, the court has been lambasted for staying a district court order based on the scanty review this court gives matters on its shadow docket. This opening with lots of criticism of people who've been critical of the court, is that normal? And what do you make of it?
This is a court that isn't getting along particularly well, Joyce. So you're asking me, is this normal? It hasn't been normal up through the Trump presidency, and yet we now have 9 justices that are largely at each other's throats and defying the collegiality that has traditionally defined the Supreme Court.
Justice Alito, aka the grumpy justice, dissented from the decision. Justice Thomas dissented as well, but he didn't sign the dissent that Justice Alito wrote. Probably due to the fact that he's in some hot water right now because he's been accepting undisclosed gifts and cash worth hundreds of thousands of dollars from a conservative billionaire. Yeah, so probably not the best time to stick your neck out. But the vote was 7-2 to stay the order. So what does that mean? Stay the order. Okay, so every court order has 2 parts. The first part is the decision. The decision is where the judge or panel of judges decide supposedly on the merits of the case. The decision is where they declare who they agree with as a matter of law. The judge or judges make a decision as a matter of law if the plaintiff is right, the person complaining, or the defendant is right, the person defending against the person complaining. If they decide the defendant is right, then everything usually remains as is. That's my apple. No, it isn't. No, it isn't. It's the defendant's apple. You like that? You like that, son? It's delicious. You better go get some Sour Patch Kids. You know why? Because you bitter. You bitter. You bitter. He owes me an apple. Wait, what? But if the plaintiff wins, the judge can enforce a judgment. That's where the judge imposes a penalty or a remedy. I'm right. He is right. That wasn't so bad. Now for the judgment. Give him your car. No! So Judge Kacsmaryk decided that the Christian fundamentalists were right. His remedy, his judgment, was that the abortion pill should be taken off the market in 7 days. The Biden administration appealed to the Fifth Circuit Court, which is responsible for overseeing the decisions in the states of Texas, Louisiana, and Mississippi. And while they didn't decide on the decision, the merits of the case, they did decide that the judgment was too harsh to impose before they reviewed the merits of the case. So they partially modified the judgment. The Biden administration appealed again to the Supreme Court to stay the judgment, along with pretty much the entire pharmaceutical industry. And the Supreme Court, by a vote of 7-2, stayed the entire judgment until they could review the case themselves. So here's where we stand. The abortion pill is currently available in all 50 states, but it does have the sword of Damocles hanging over its head. When the case gets to the Supreme Court in perhaps a year or 2, the abortion pill may be allowed to continue to be on the market under current FDA guidelines as is, continuing the status quo. Or it may be banned entirely. Or it may be restricted in some intermediate fashion between a total ban and its current state of national availability. So where does that leave us? First, with a very unpopular Supreme Court.
Welcome back. A new low for the U.S. Supreme Court. A new nationwide Marquette Law School survey just out finding just 38% of Americans approve of the U.S. Supreme Court. 61% disapprove of how the court is handling its job.
Heilman, I want to draw your attention to a new survey that Gallup took that shows confidence in the Supreme Court is lower now than it has ever been. According to the latest Gallup poll, just 1 in 4 Americans say they have a great deal or quite a lot of confidence in the nation's highest bench. That's the lowest the number has been in the nearly 50-year history of the survey. The previous low was 30% back in 2014.
They are widely out of sync with the country. Second, with a judge that is willing to substitute his judgment for the FDA's. He is already staunchly against abortion. We know this. But he has also expressed negative views toward birth control and who knows what else.
People who experience same-sex attraction are not responsible individually or solely for the atmosphere of the sexual revolution. You know, it's a long time coming. You know, it came after no-fault divorce. It came after we implemented very permissive policies on contraception. You know, the sexual revolution has gone through several phases. We just happen to be at the phase now where same-sex marriage is at the fore.
He is willing to cross lines as he just demonstrated. What does that say for the state of medicine in America in the near future? How far will one man or one circuit court go? What's next? Birth control? Plan B? Vaccines? Third, this shows that the pro-life movement is in no way, shape, or form looking for a states' rights solution. Rather, they are looking for a national ban on abortion, medical and procedural, all over the United States.
Standing here in the first days of post-Roe America, we must resolve that we will not rest, we will not relent until the sanctity of life is restored to the center of American law in every state in the nation.
Leading anti-abortion group blasted Donald Trump after his campaign said he believes states should decide abortion laws. On Thursday, a Trump spokesman provided this statement to the Washington Post when asked whether the former president supported the 6-week abortion ban that Florida Governor Ron DeSantis signed into law. Quote, President Donald J. Trump believes that the Supreme Court, led by 3 justices which he supported, got it right when they ruled this is an issue that should be decided at the state level. In response, a prominent anti-abortion group, Susan B. Anthony Pro-Life America, issued a scathing statement that reads in part President Trump's assertion that the Supreme Court returned the issue of abortion solely to the states is a completely inaccurate reading of the Dobbs decision and is a morally indefensible position for a self-proclaimed pro-life presidential candidate to hold. It continues, we will oppose any presidential candidate who refuses to embrace, at a minimum, a 15-week national standard to stop painful, late-term abortions while allowing states to enact further protections.
Finally, this decision and language in it was highly questioned by most legal scholars. In addition, pro-life candidates are losing at the ballot box in every election thus far.
Voters in Kansas turned out in record numbers yesterday and overwhelmingly rejected a proposed amendment that would have removed the right to an abortion from the state constitution and opened the door to the Republican legislature passing restrictions or an outright ban. The Vote No side celebrated its victory last night.
I'm super proud to be from Kansas tonight, and I feel like my state just showed up and boldly told me that they are going to take care of me and my female friends and everyone that can get pregnant in the state of Kansas. We are protected tonight.
And abortion has literally been on the ballot in some states. Let's look at where we are with Proposition 3 in Michigan, the right to abortion. Yes, right now with 55%.
3 states had an abortion measure on their ballots. California, one of them. Prop 1, yes, there is a right to abortion. And Vermont, it amends its constitution yes, a right to reproductive freedom, reproductive autonomy, as the measure puts it in Vermont. That's a change to the Constitution.
NBC News is projected a result in the very important Wisconsin Supreme Court election tonight. Janet Protasiewicz is the more liberal of the two candidates. Dan Kelly, the more conservative of the two candidates. This is considered broadly to be the most important election in the country, the most consequential election in the country in the year 2023. As you see with these elections here, the projected winner is Janet Protasiewicz, the more liberal of the two judicial candidates here. This has very big consequences for Wisconsin and indeed for the country. I will just point out a couple of things here. This may very well mean that there is a deciding vote in the Wisconsin Supreme Court that results in abortion being legal in Wisconsin instead of illegal.
But pro-life Republicans are now looking to move the goalposts, at least in Ohio.
The months since the Supreme Court overturned Roe v. Wade, voters responded by upholding abortion rights in every state that put it on the ballot. Now, anti-abortion activists are trying a new tactic for upcoming ballots, moving the goalposts or avoiding the voters altogether. The New York Times reports Republican-controlled legislatures and anti-abortion groups are trying to stay one step ahead by making it harder to pass the measures or to get them on the ballot at all. The first state to test this new strategy is Ohio, a coalition of abortion rights groups pushing to get a vote on a constitutional amendment in November that would stop the state from being able to ban abortion before 24 weeks.
Why? I'll tell you why. Because 65% of Americans believe abortion should be legal in most or all cases, and that means it would very likely pass in Ohio. And they just need a simple majority. But as the New York Times writes, Mika, Republicans in the state legislature are advancing a ballot amendment on their own that would raise the percentage of votes required to pass future measures to a 60% supermajority.
The real question is, as the courts have clearly shifted right and people have clearly shifted left, will some people in the pro-life movement choose their interpretation of God's will over the will of the people, which was ironically also granted by God?
Signing off. Peace. Hey, if you like this video, please smash that like button and hit subscribe. We would love to see you again. So take it easy. Peace.